Council's website within 24 hours of the meeting. Remote participants using Teams, I don't think we have any today. May use the hands up icon on your screen. I don't think we have any. Members and officers, please remember to switch your microphone on when speaking and off when you finish speaking, and speak directly into the microphone. Would in-person attendees please switch off your mobile phones or place them on silent? So, I need a copy of the agenda. 1 second. Have we got any apologies for absence?
Yes, Chair, we've received 2 on behalf of Councillors Fatima Begum and Andrew Martin.
And thank you. And I've got one of my lovely youth councillors who's shadowing me in the audience today, so give them a wave. So we're moving on to minutes. So I have minutes for the meeting of the 17th of March 2025. Has anyone got any questions on the minutes? Any corrections? No? You're all happy that they are an accurate record? Yes, that's fine. And then we have minutes of the meeting of the 20th of May. Yes, Paula?
I didn't attend that meeting, I think Andrew did.
Oh. Okay. So, yeah, you're in as being present. Okay, thank you. And Andrew, were you there? Yes. Okay. Have we got any other questions or corrections? Other than that, correction, is everyone happy that they're an accurate record? Yes, okay. Oh, can I sign them, or do you need to edit them first? Okay. You can. 23 to section 106 stuff. Yeah. So, 23 to section 106 stuff? Yeah. Yes, okay, fine. Section 106, Local Government Finance Act 1992. So those items on the agenda affected by Section 106 of the Local Government Finance Act 1992 will be identified at the meeting. Any members affected are reminded that they should disclose the fact and refrain from voting on those items. Do we have any disclosures of interest? No. Okay. Okay, have we got any urgent business?
None, Chair.
Thank you. Okay, lovely. So moving on to reports. So, first report is a report on complaints against members.
Thank you, Chair. This is a report that I present periodically to the committee to let them know how many complaints we've had during the year and the status of them. There have been quite a flurry of complaints during the first half of this year, 11 in total, which compares to 4 in the whole of the preceding year and in the year before that. However, most of the complaints, 9 out of the 11, have been dealt with at the initial assessment stage and have been either withdrawn because we've been able to reach informal resolution, that was the case in 2 of them, or have been rejected either because there was no evidence to support the allegation of misconduct, or because the code wasn't engaged because the member was acting in a personal capacity at the time of the alleged incident. We are in the process of arranging a local assessment panel to hear the remaining 2 cases, and I very much hope that that will happen possibly by the end of this month or early next month. Thank you, Chair.
Thank you. So that's a update from Mark. Have we got any questions No. Okay. Are we all happy to note that update? Yes. Yeah, okay. Thank you. So, next item is about the operation of the Council's whistleblowing policy, which I also turn to Mark.
Thank you, Chair. Yes, I report annually to the Committee on the operation of the Council's whistleblowing policy in the preceding year. During 24-25, 7 complaints were received. 1 to the disclosure of personal information, 3 to activities in social care establishments, and 3 to staffing issues either within the council itself or a service provider to the council. 2 of the complaints were received anonymously, but obviously all of the complaints were dealt with in confidence. At the time of writing, 1 of the complaints remained unresolved, and that was in relation to one of the social care establishments. Of the remaining 6, 1 was dealt with through a more appropriate HR procedure, a grievance procedure. 1 was closed by Ofsted by an investigation by them. 2 were not upheld, and these related to 2 of the staffing issues, and 2 relating to the social care establishments were closed after corrective measures had been put in place between the council and the provider. It's noticeable that the whistleblowing policy continues to be used for raising staffing issues that are of personal rather than public interest, and it should be borne in mind that the whistleblowing procedure is derived from the legislation that provides for the raising of concerns in the public interest. The council does, of course, have a number of appropriate procedures for dealing with HR matters. However, having said that, the number of complaints that we've received of that nature are not excessive, and therefore I wouldn't be recommending that there need to be any changes to the policy to deal with that particular issue at this present time. As members of the committee will be aware, as I've reported previously, Part 2B of the Council's Constitution, Responsibility for Functions, places responsibility on the Audit and Governance Committee to consider general issues and statistics in relation to the whistleblowing policy, and a report was made to that committee on the 10th of July 2025, but the committee has made no recommendations to you this evening for any changes to the policy. Accordingly, you're asked to note the report.
Thank you, Mark. Right, do we have any questions on the report? Councillor Franks.
Yeah, thank you. I'm just a bit curious about anonymous complaints. I guess, like every other councillor, I occasionally receive anonymous complaints, and my usual response is, unless you're prepared to identify yourself, I'm not prepared to enter into conversations with you. I just wondered whether Mark might give us a word or two of how you approach anonymous complaints and the circumstances in which you might take the attitude that I have just described, or where you might feel it's necessary to investigate in spite of the anonymity. Also, while we're at it, a word or two on whether anonymous complaints means that you know the identity but are not divulging it, or whether you genuinely don't know who it's from. I think it would be helpful.
So the council's policy does allow for anonymous complaints to be considered subject to being able to satisfy oneself that, and me in this case, as the officer responsible for the policy, that the complaint has a degree of credibility, and that it can effectively be investigated by other means than dealing with the actual complainant. So we are required to take them through the process if we think that there is sort of sufficient grounds to suggest that the complaints themselves might be vexatious, might not be vexatious, and that the complainant is legitimately concerned at revealing their identity. So some complaints that we do get are absolutely anonymous. We have no idea who they are. They come in the form of a letter sort of shoved under the door, if you like, or an email from an address that's anonymous 123, etc., etc. Other complaints are, and this is generally the case, certainly with 5 out of the 7 that we dealt with, are from people who name themselves but do ask to be treated anonymously as we go through the process.
Thank you, that's helpful.
John Jones.
Thank you, Chair. Yes, I've been around for long enough to know that up to about 8 years ago, the whistleblowing policy was contracted out to an independent company. And that was in order to maintain independence from the council's officers. It was taken in-house, I assume it is still in-house, it's taken in-house for cost-saving reasons, which is understandable. I'm wondering whether the Audit and Governance Committee have looked at the effect of that. I'm particularly thinking about whether the number of anonymous complaints has gone up because it is being dealt with in-house, or indeed whether there is any evidence to suggest that people are more reluctant to raise it for reasons of retaliation or not being promoted or whatever it may be. Any thoughts?
I'm not aware whether Audit and Governance Committee considered the impact of bringing it in-house sort of at the time that happened. We can perhaps look back at reports that went to the committee at that time to see if there was any assessment of the impact. But actually, I don't think it has had a deleterious effect on the willingness of people to come forward to identify what they see as matters of public interest. The number of anonymous complaints that we receive, strictly anonymous complaints, it varies, and actually 2 is probably around about the average. So that doesn't appear to be a particular concern. I think it's understandable that people, whilst they would be prepared to reveal their identities to me as the monitoring officer with responsibility for the policy, might not want their identities to be revealed further. And we always respect that, of course. But I'm not seeing any particular issues with regard to the way the policy is operating. We get roughly the same number of issues drawn to our attention year on year.
Do we have any further questions on whistleblowing? No. We're all happy to note the report? Yes. Okay. So, we move on to the Chair's annual report. So, this is an annual report of the work of the committee. So, it's due to be at the next full council on the 11th of November. So, Mark, do you want to run through that?
I think you've said it all for me, Chair. Yes, this is the customary annual report of the Chair on the activities of the committee for the preceding year. It contains, as usual, records of attendance of members at committee meetings, with the acknowledgement that that represents only a very small element of what members do in terms of the work that they carry out for constituents, work that they carry out on outside bodies. So it's simply a summary of activity, not a measure, and also contains the training records. It appears that the training records may be incomplete for 24-25. It certainly seems to me that there were more activities going on in that year than have been recorded, and I can only apologise for that omission, but I've been unable to track down the records in order to make make sure that it is a complete record. So I have asked to make the team to make sure that accurate records are kept, so that when I come to report for the current year, we will have seen a fuller picture of the courses that members have undertaken during the period.
Thank you, Mark. Right. Now, first off, do we have any questions on the draft? No. Does anyone have any thoughts on any amendments they might wish to see, or have any comments as to it? Councillor Henniff?
Yeah, I'd like to thank whoever put the report together. I think it's really good to see the transparent nature of members' attendance and training records. And also goes to show just some of the sheer amount of work that goes into being a councillor, and some of the training that they have to go through. And then the public can appreciate the depth of some of the roles and duties undertaken, and hopefully encourage more to come forward. So I'd like to thank the report and its comprehensive nature.
Yes, thank you. Do we have any further comments? Right, is everyone happy to approve the draft report? Yes. Perfect, thank you. Okay, lovely. It is very complex. So, next we have the review of the procedure for dealing with allegations of misconduct.
Thank you, Chair. One of the first things I did when I became the Council's monitoring officer was to develop a procedure for dealing with allegations of misconduct by councillors, mainly out of self-interest, because I actually had to deal with a couple of complaints pretty early on, and I couldn't find any advice on how to go about it. There was a page in the Council's Constitution which was intended to be the procedure, but it says this page is being updated, which wasn't terribly helpful. So I thought, well, we'd better get this clear, because it's very important that members of the public know how complaints are going to be dealt with. It's very important that any member of the council who is subject to the procedure or takes part in the procedure knows how it's going to happen. And it's helpful for the monitoring officer to know how to conduct themselves. So I found various models that were used by other councils and sort of cobbled them together in what I thought was a sort of serviceable procedure. And fine, yes, it sort of worked pretty well for the 4 years. But at your last meeting, you asked me, given the lapse of time since it's been introduced, just to have a look at it, to see whether it was clear, whether it was effective, whether it was serviceable, and to bring forward any improvements that I thought was necessary. So that is what I've done. And whilst the marked up copy of the procedure at Appendix B looks a little bit messy, it looks as though there's a lot of changes. Mainly it's about shifting things from one place to another to give them a more logical sequence, and also to break it up into clear stages, so that we have the initial assessment stage, we have the investigation stage, we have the adjudication stage, and the appeal stage. And the way it had been developed in the first instance had led to a bit of a lack of clarity and a bit of duplication. So, for example, you know, one of the first questions that you ask when you get a complaint is, well, was the member acting in their capacity as a councillor at that particular time? But that appears twice in the procedure. Well, you only actually need to do it once, because if they weren't, then that's the end of it. The code is not engaged. So it's tidied up those sorts of things, really. So it's not substantial changes to how we go about it, apart from two. So the current procedure currently envisages situations where the monitoring officer, without reference to a local assessment panel, can instigate a formal investigation and indeed adjudicate on the outcome of that investigation. I do not believe that to be appropriate, and I think that that should be removed from the current procedure, and the changes I've made do that. Now, the reason I don't think it's appropriate is because I think the monitoring officer throughout the process needs to be neutral. And also, I do not consider it proper for members to be judged by anyone other than their peers. So that's the reasons for that suggestion. But then I'm suggesting something that you might see as a sort of curtailing of the procedure, because it's been clear to me in many cases that there are situations where a complaint is self-evidently upheld. So, for example, if somebody does not declare an interest when they should have done, and that is a matter of record, either in the minutes of the meeting or of the or on the live stream, then it seems to be a bit daft to go through the whole procedure of taking it to a local assessment panel to decide whether there is a case to answer when there self-evidently is. And then for the local assessment panel to commission an investigation. Well, an investigation into what? Because everything is self-evident. So what I'm suggesting is, in those circumstances, subject to consultation and the agreement of an independent person, such a case should be taken directly to an adjudication panel, for the adjudication panel to decide whether they believe the complaint is upheld, and if so, what the sanction should be. So that makes the process very much quicker and easier in those particular circumstances. Those are the only substantial changes to the procedure. As I say, everything else is pretty much tidying up, removing duplication, putting a more logical sequence of events into place. And therefore, I would ask you to adopt the revised procedure as set out at Appendix A.
Thank you, Mark, and thank you for supplying the track changes, because it made it very more helpful to see what has changed. Right, Councillor Khan.
Thank you, Mark. One of the things that we had discussed in the past to make sure that these procedures were aligned with the LGA. Now, you make a reference to adopting from other councils. Do you mind mentioning which they are, and are they in line with the LGA procedures?
So we've used the LGA Model Code of Conduct as the basis for our own, and I have had reference to the guidance notes that the LGA provide for dealing with allegations. Our current procedure was substantially taken from that of Milton Keynes, with some additions from elsewhere. It is consistent with the sort of procedure that you would expect to see in relation to the model conduct, the model code.
My just concern is that sometimes we think ours are not correct, and you're adopting another councils, and you later down the line think that, you know, it wasn't a good one to adopt. What we want to make sure that it's consistent with other councils as well as the local government association. That's what I'm asking.
Yeah, I think also, as I say, it is consistent with what you would expect of a a procedure for dealing with allegations. I think we also have to ask us, does it work for us? Does it feel right for us? As I say, the current procedure has been serviceable. It's certainly given a great deal more clarity to how the process operates than was previously the case. It just now needs some tidying up.
Does that answer your question? Yes. Okay, right. Councillor Franks.
Yeah, thank you. The proposed changes look perfectly sensible to me, but I often wonder whether perhaps as sitting councillors, particularly for long-serving ones like myself, may be a bit too close to what's going on to make a completely impartial judgment. So whilst they look fine to me, I really would be interested to hear any comments any of the independent members may have to make on the suggestions.
Well, Andrew.
I'm going to comment on the addition of paragraph 4.4, which is allowing the monitoring officer to bypass the local assessment panel. I really support that, because having sat on several local assessment panels where it was absolutely clear there could only be one outcome, it did somewhat feel like it was unnecessarily delaying the process. So I think it's a really, really positive move, and given this sometimes takes a while to organise these meetings, hopefully it will streamline the process, make it more efficient and quicker.
Couldn't agree more. John Jones.
Thank you, Chair. Yes, I'm looking at 4.4, and I'm also congratulating Mark on the work which he's done on this document. And I'm speaking as with one of my other hats on, which is as an independent person to a number of authorities, including Milton Keynes. And on 4.4, you suggest that a self-evident breach of the code, he/she may choose, but only following consultation with and the consent of the independent person, further complaint on. Whilst I wouldn't like to downgrade the independent person, I think consent is a bit strong. You should, I think, be able to do it anyway without, I mean, by all means consult, take advice, no problem with that at all. But I wouldn't like to take on the onerous task of providing consent if it was me.
So you'd prefer if it says under the advice of the independent person?
Yes,
Yeah.
Following
Similar.
consultation with the independent person, I think probably is strong enough. And whilst I'm sort of on my feet, I've got a couple of other points. If I may,
Go
Chair.
ahead.
Okay. A very quick one on over the couple of pages, 6.8, where there is reference to occasions when the police may need to be involved. And I'm looking at line 5 of 6.8, where it says, for example, following consultation with the Chief Executive, referring the matter to the police. I think there should be if evidence of criminal activity has been found, rather than of. That's the printer coming out in me, I have to say. Okay.
That has been corrected in the clean version at Appendix A, I'm glad to say.
I was going to say, because I'm reading it.
Right, okay.
Well spotted, John.
And yes, on the same page at 7.1, I'm curious, and I'm going to develop this slightly, that the local assessment panel is held in private. Local appeals panel, if it is needed, is held in private. The local adjudication panel is held in public. Now, I haven't got any problem with it being held in public. I'm all for public accountability, absolutely. The difficulty I have is that at the moment the procedure seems to allow for the complainant, first of all, to be present, they're a member of the public, why not? But also are invited to comment or cross-examine almost the subject member. And that concerns me because it means that there effectively are two prosecutors, if I can put it as strong as that. And they are taking advantage of their position. And I think it's inviting a contretemps between the two parties, which maybe could be avoided. I can't quite see why the complainant should have the right of audience, if you like, when the matter has already been dealt with by the investigating officer, who is therefore presenting that report and fighting what I'm referring to as the prosecution. This may not be the place to discuss this, and perhaps you could go on to a future meeting when people have had the time to think it through. And I'm quite happy for that if that's the will of this committee. But it just seems to me that it needs to be addressed, because it seems an odd way of going about it. And I think it is not common practice.
Mark might be able to clarify further. My understanding of the current process is subject member and the complainant are invited to attend should they wish, but their involvement is at the discretion of the chair, to an extent.
That is true of a local assessment panel,
Oh, is this
Chair, yes,
right?
but at the local adjudication panel is more of a hearing. The procedure that we currently follow, I think, was adapted from a sort of HR type procedure. And it sort of assumes that the investigating officer will be in the sort of role of the sort of management rep that you would typically find in an HR procedure, who would be bringing the case against the subject member. But of course, the outcome of the investigator's report may be that they exonerate the subject member. In which case, you know, if the subject member is able to question, then you could have two people for the defence rather than two people for the prosecution. So I think there is a point there that needs to be looked at, and we need to consider that procedure itself to see whether it is working properly and whether there is some other way of enabling the complainant and the subject member to participate in the hearing, but without getting into that sort of adversarial position that you described. So I think we can take that away and look at it.
Okay. Yeah, Mark, if you can have a look at that. Any further questions or comments? Councillor Fry, go ahead.
It's just around the terminology. In some parts, we've got reference to the subject councillor, and some parts it's subject member. It's just having a consistent term throughout the document.
Yes, indeed. I couldn't agree more, Councillor. It should be consistent, and I'll make sure it is in the final version.
Okay. And on point 3.3, the bottom line, there looks to be a missing S. So it should be set, I believe. Yes. Okay.
Thank you very much. Okay. Anything further? No? Okay, that's not a problem. So, Mark's going to have another look at that bit. Is the committee happy to approve the revised procedure for dealing with our current allegations of misconduct as is set out, as Mark set out? Yes, Chair. Yeah? Okay. So no one says no, I'm taking that as a yes. Perfect. So, we have the work programme.
Thank you, Chair. Yes, there's nothing on it at the moment for your next meeting.
Well, that's exciting.
We may well have the procedure for dealing with local adjudication panel hearings. I think that's a useful suggestion to bring that back. But I would ask you, Chair, if you would ask any members of the committee whether they have any particular issues that they would like to see examined.
I was just going to ask the same thing. Has anyone got any thoughts of anything they think we should look into, review, any procedure that might want to be updated? Anything we might need to have a think about? No. No one's got any burning thoughts, any suggestions, any things like this? Right, well, feel free to drop it in an email if you come up with something. Otherwise, we'll have to wait and see, because the next meeting is not until February. Oh, March, sorry. The deadline is not until February. That's what I meant. The deadline for the next meeting is not until February. So we've got plenty of time to think about it if suddenly you come up with something. Okie dokie. Okay, so with that, I think that is all of the business. No? Yep. Okay.